come out of executive session on item number 2. Is there a motion?
I'll move it.
Second.
It's been moved and seconded. Go ahead and take a roll call vote, please.
Leonard Knapp,
Yes.
Robert Beer,
Yes.
Sabrina Richardson,
Yes.
Jared Rickey,
Yes.
and Eula Sidney.
Yes. Before we entertain a motion on coming out of executive session on number 6, we'll make note of the fact that Rod Meir excused himself from the executive session prior to any discussion of number 6, and he recused himself from consideration of that matter. So when we take a vote to come out of executive session on number 6, no need to call Commissioner Mears. Okay, thank you. We have a motion.
I'll move. A second.
Moved and seconded. Roll call vote, please.
Leonard Knapp,
Yes.
Sabrina Richardson,
Yes.
Jared Rickey,
Yes.
and Eula Sidney.
Yes. Okay, we are now out of executive session. Moving on to item number 2, is consideration of a request for investigation pursuant to LSP Rule 16.2 and formal charges pursuant to LSP Rule 16.4 by Troopers Randall Dickerson, Trooper George Harper, and Trooper Dakota Moss. There's been briefs. Is there any argument? We've all reviewed.
The briefs are on the other matter.
Oh, there's no
Three.
briefs on this. Oh, I'm sorry.
Oh, we're on number 3 yet?
No.
Okay, I'm sorry. But I believe the 3 is the argument for 2, frankly.
It's up to you, however you want to do it. I just want to make it clear that the briefs were with number 3.
Why don't we go ahead and go on to number 3, and then we'll hear their argument relative to that, and then we'll address 2 and 3 at that time.
Yes.
Is that Anyway, although I'm headed for the wrong item, obviously we've looked at the briefs, we know, but it's this short argument that you guys want.
Mask for argument, okay, take it off while we're speaking. Thank you. I've been vaccinated too, for whatever comfort that gives anyone.
Where's your card?
I actually have a picture of it on my phone. May I proceed? Chairman and Commissioners, I'm Michael Dubose. This is my associate Adam Karamanis. We represent 2 Troopers Dickerson, DeMoss, and Harper. A couple things I'd start out by saying. First, the state police argues in brief that we're trying to stop administrative investigations. That is not true. All we're saying is the state police must follow the law like everybody else. And the law prescribes how investigations are to be conducted. So that's the first point. The second point I would make is we filed the appeal, we filed a request for investigation, and we filed a formal charge. I think we could focus, because we could argue all day over whether we have a right under the appeal to the relief we seek, but I don't believe there's any dispute that we're entitled to the relief we seek under the investigation articles. If you look at the Constitution, it expressly provides the Commission under Section 48 of Article 10 with broad and general rulemaking authority. Then it lists the matters on which it can adopt rules. It says including the power to adopt rules regarding regulation of employment, promotion, demotion, suspension, and so forth. Then the Constitution further provides that the Commission may investigate violations of this part and the rules that it promulgates. So the Commission's authority to investigate the rules it promulgates is set forth in the statute. There's no dispute that the Commission has directed how administrative investigations that seek to impose discipline are to be conducted. There's 2 ways and 2 time frames. One is when a formal complaint is made. There's 14 days.
And we're really familiar with.
And I understand, but just from my thinking. And the second, obviously, is 12B, 12.18B. That's when they learn of it. Now, the incident of July 19, 2016 and May 23 or 26, 2020, there's no dispute with respect to the incident of May 2020 that the Troop F commander reviewed the matter, which would have triggered the 18B 14 days. If we were allowed to put on evidence, it would show that Captain Reeves was aware of it, he learned of the incident, and he acquiesced in the reports of general counseling that were issued at that time. So the administrative investigation provision, it terminated on its own because the Troop F commander saw no need to elevate it to that level and handled it in troop, which the law this commission passed allows. We could also look at Colonel Davis. On December the 9th, he ordered criminal investigations. Let's presume that that was our first learning of the incident. He ordered criminal investigations, not administrative investigations, criminal investigations. It's extremely unusual to see a criminal investigation initiated first. This commission has given the troop and the colonel and the state police the authority to, if you need a criminal investigation, we'll stay the administrative investigation, but you have to open it first. It only stays the 60-day period within which it must be completed. That 60 days doesn't get to start running until it's initiated. So it has to be initiated, but for whatever reason, the state police opted to proceed only with a criminal investigation and not to launch an administrative investigation. So here we are with our request for investigation, and the commission has the power. It says to conduct investigation when it has reason to believe that the rules are being violated, present tense, or have been violated. Then it says the commission may issue appropriate orders in any such case. So the state police says, look, we can do whatever we want.
You do agree, though, that that's discretionary?
Well, I don't believe it is. I believe when you look at the
Why don't you
report,
read the words again for us?
right, it says the commission is empowered to conduct investigation whenever it has reason to believe the
Is there
provision.
anything in there that says we're mandated to do that?
No, but I would go to under 16.2, it talks about requests for investigations, and then 16.3b says, upon receipt of a request for investigation, the executive director or the executive director's designee shall conduct the investigation as warranted based on the facts. So I believe 16.3b mandates that once there's been a request for investigation, which there has been, that
As
there be an
warranted by the
investigation.
facts.
I'm sorry, sir?
As warranted by the facts.
It says the investigation shall be conducted as warranted by the facts, but there shall be an investigation. And look, this is a rather odd where the state police says we don't have to follow. We don't have to follow the law. And all eyes of the troopers are on this commission today. If this commission says, you know what, all these shalls, sometimes they mean it and sometimes they don't. We'll let the colonel decide when they mean shall and when they don't. We'll let the colonel decide which of our laws he has to follow, which ones he doesn't. This is precedent. So either your laws mean what they say, and shall means what it says, and the time periods mean what they say, or they are meaningless, and this commission is without authority, or it's abdicating its responsibility. Because the laws have been passed. If you want to change the laws, if you don't like them, that's one thing. But the laws are on the books. And it says that they shall initiate the investigation within 14 days. The state police won't even argue that based on the December 9th date, they did not do that. And you gave them the authority to open both simultaneously and let the one be stayed while the criminal investigation continues. But it says, they say you have to wait till it's all over. Wait until everything's happened, then you can clean up the mess. Let us do the damage, then you... Well, that's not what the rules say. The rules say when the rule is being violated or has been violated. And then it says you can issue appropriate orders. So we're saying, look, the rule is being violated. No one's going to dispute that. Any investigation will show that conclusively. So it says, they say, well, you can't stop the investigation. Well, what would be the appropriate order to stop a violation of a rule that's being violated now? The appropriate order would be to stop violating the rule. That would be the appropriate order. What other order would you give to rectify the ongoing violation of a rule? If I'm driving 85 miles an hour and a trooper's in the car and he wants me to stop speeding, he'll make me stop driving over the speed limit at that point. So there's no other relief than to stop the investigation. The troop, you know, they say, well, we don't have to follow the law. So if they don't have to follow this one, which others do they have to follow? Do they have to follow the 60-day period? Do they have to give notice? Do they have to inform of who's present during the investigation? I mean, which other ones are not required? Because this speaks in mandatory terms, and this is for the protection of the officers. It secures their due process rights, their property interest in their jobs. The courts have been clear on that. And it would be a deprivation of their due process rights to allow these investigations that are clearly illegal. By the troops' own, albeit likely admission, they're outside the 14 days. So all eyes of all troopers are on this commission today. Either this commission fulfills its constitutional mandate and it enforces not somebody else's rules, but it enforces its own rules. These are your rules. And it does exactly what it says, and it tells the state police, look, the law applies to you just like it applies to everybody else, because these are not merely rules. As y'all well know, the Constitution says these have the force and effect of law. I'm sorry?
2 more minutes.
Yes, sir. And so these are statutes that were enacted by this legislative body, and so if you don't enforce the rules, then who is? Then when do they get enforced? I mean, the one thing that troopers have to rely on, and the public has to rely on, is consistency. Consistency in the laws and consistency in the enforcement of the laws. And again, the mechanism was there at all times for the state police to conduct their investigation if they so desired. But they did not do it according to, once again, your laws. And we believe the only remedy is for this commission to conduct an investigation, confirm what I'm saying is true, most of which is in the exhibits which I would offer in the evidence at this time attached to our initial filing, and allow us to put on the testimony of the witnesses that would confirm everything we've said. And it would show that the investigations are untimely and they are therefore illegal. Thank you.
Department head response.
Yes, sir. On behalf of the appointing authority, we oppose all the relief that has been requested by the troopers. You've asked for a brief on the legal issue of whether this commission has the authority to stop the investigation. So I will start with that as opposed to some of the merits that the opposing counsel has gotten into. So we're talking about the State Police Commission rules. These are rules that this body has enacted to set, in this instance, minimum standards regarding administrative investigations. And those are set forth at Rule 12. And the violation that is alleged to be committed by that the troopers have alleged against the appointing authority is a 12.18 rule violation regarding the timeliness of initiating the investigation. This commission, in enacting those rules, provided for a penalty. And that penalty is set forth at 12.20. And at 12.20 it says any disciplinary action taken against the Louisiana State Trooper in violation of these rules. So when you violate these rules, this is what happens. May be reduced, modified, or reversed by the commission in accordance with Rule 12.20. I mean, in accordance with the Rule 13.20. So you've provided for the rule and you've provided for the remedy. And that remedy is exclusive, as we set forth in the memo.
It doesn't actually say
regard to
that's the exclusive remedy, though, right?
I'm sorry?
It does not say that is the exclusive remedy.
The rule doesn't say it's the exclusive remedy, but the Supreme Court has said that it's the exclusive remedy. The Supreme Court has gone on and has entertained situations where you've prescribed the law, the legislature has prescribed a law, but did not provide for a penalty. So the first case at issue on that is in the case of Marks versus NOPD. In that case, it was a law enforcement officer, and the law enforcement officer said that his investigation had not been timely under the statutory minimum standards set by the Louisiana legislature. And the court reviewed that case and found that it looked at the statute as enacted, which had the same sort of shalls in it. Shall initiate investigation on this date, and it shall be completed on this date. And so he alleged a violation of those timeliness rules. And when the Supreme Court looked at it and they looked at the statute said shall, but it did not provide a penalty. And the penalty that was being requested was reversal. And the Supreme Court said, no, you can't do that. If the penalty is not provided, the result is not dismissal. So the court also looked to an analogous situation with the New Home Warranty Act, where you had a homeowner who had a new home built, and there were problems with that. He sued his contractor, and the contractor cited to the New Home Warranty Act. And the homeowner said, I wasn't even on notice of the New Home Warranty Act. He did not give me the things that I was he did not give me the notice that I was entitled to. I was not aware that I was bound by this, and therefore I should be able to go outside and get a different remedy. And the Supreme Court in that case said, no, the remedy is provided. It is the exclusive remedy provided, and you can't go outside that. So with regard to a violation of Rule 12, I'm not talking about any of the other powers of the commission, but with regard to a violation of Rule 12, any of those provisions, the exclusive remedy has been provided, and that is at 12.20. Additionally, you know, I want to point to the importance of an administrative
Isn't there a
investigation.
difference though when you cite these cases where a different body has to do the interpretive work versus the body that actually passes the rules?
Well, I didn't have anything on that, but at this, when you enacted it, you were sitting in a legislative position. And here, you're sitting in your power of review. And that power of review goes to discipline, and it goes to discrimination. So that was the second point. The appeal on the rules violation has been declared by this commission and in previous cases, and the First Circuit and the Supreme Court, that Rule 13.1C, for an appeal on a rules violation, that rule exceeds the authority of this commission. So this commission is a legislative body. It was given powers by the Constitution as a legislative body, and it was also given very limited constitutional authority as a judicial reviewer, and that judicial reviewer is limited to discipline and discrimination. So
Rulemaking, we have the power to make rules.
yes, sir, but I'm talking about in a review capacity, in a review of conduct capacity, an appeal capacity. So we would argue that the case of Berry versus Department of Public Safety sets that precedent, that there is no appeal on a rules violation, that this commission doesn't have authority to review a rules violation. There are other provisions in the rules to do that. Finally, I want to talk about our right to an administrative investigation and how important an administrative investigation is. Opposing counsel talks about the importance to enforce rules, and you know, when you violate a rule, how bad that is. But with regard to an administrative investigation, we're looking at reviewing a violation of the public trust. So what's more important, a violation of the rule or a violation of the public trust? And if this administrative investigation is stopped at this point, and opposing counsel says, well, we're not asking for the administrative investigation to be stopped. Well, a review of their pleading shows that they asked that all three cases be closed and dismissed, AKA the administrative investigation be stopped. They went on to enjoin, which we're going to hear with Judge Johnson at 1 o'clock, they moved on to enjoin all other administrative investigations coming out of the two incidences. So that means we can't review anything that came out of those two incidences. So that's training, that's supervising, that's processes. So they've stopped us looking into why this happened. So they've submitted all their pleadings on, well, we've addressed it, they've already been charged criminally. Well, there's a different interest. In a criminal investigation, the people are not forced to give a statement against themselves. They're not forced to talk about their public duties. But in an administrative investigation, we've got to get to the answers of why. We've got to know why this is happening. Were people trained to do this? Was there a culture of doing this? Was this approved by supervisors, or was this not approved by supervisors? Do we have a limited problem, or do we have a bigger problem? And the administration has to be able to look into those things. And the Supreme Court of the United States has said that we have a right to look into those things. When we talk about Garrity, and y'all all know that the Garrity line of cases stands for the fact that when you put somebody under an administrative investigation and you compel their testimony, or you compel that statement, you cannot use that statement against them in a criminal case. That is the balance that was struck because the Supreme Court and the lower courts saw that the need to do an administrative investigation was so important. It was so important that it could make someone give a statement against interest. So you could force them to give a statement against interest, and it's supposed to be truthful, we can enforce that as well. And the trade-off is that we can't use it against you in a criminal case, because it's so important that we achieve it, that we learn it in the administrative case so that we can cure our problems. And so, you know, that's the Garrity line of cases, and the Garrity line of cases stand for the fact that you cannot refuse to account for your public duties when you are a public employee to your public employer and still keep your job. And what this appeal to do was to stop them from having to give a compelled statement. This is a Garrity issue, even though they didn't couch it as a Garrity issue. They're trying to stop the investigation before it gets to the point where somebody says, you need to tell me what happened, and you need to tell me why it happened, and you need to truthfully tell me why it happened.
2 more minutes.
So, commissioners, I think I've given our primary reasons why you can't stop this administrative investigation. I also want to assert to you that this whole matter is premature because of the fact that discipline has not been eked out. I don't know whether discipline will be administered because the investigation has been stopped. But to call it an appeal at this point, there's no right to not be investigated. There's no right to not have to give a statement. But the review process and the due process you've already provided for, and that is your review of any discipline that comes out of it, and a weighing of, was there a prejudice? Was the delay a prejudice? And you get to weigh that at the appeal of any discipline. But nothing has occurred yet. Again, you have provided an exclusive remedy for a violation of Rule 12. It's right here in the language. You can reduce it, you can modify it, and you can reverse it in an appeal on a disciplinary action. Thank you.
In brief response,
Very brief.
very brief. First, the New Home Warranty Act says it's the exclusive remedy. Second, we are trying to say these investigations must stop. Only the ones in, with respect to the 3 troopers I represent, the catch-all language, but I wasn't aware if there were any others that pertain directly to them. I'm not trying to stop any other investigation that might be timely, and I don't represent anyone else. You're correct. It does not say it's the exclusive remedy in 12.20. And we're not saying they cannot conduct it. I'm just saying that from a little old country lawyer in Monroe, I thought the law applied to the state police. The law tells them how they have to conduct it. She says, it's so important, it's so important. Well, why didn't you do it according to the law? Why did you first go to a criminal investigation and then not pursue any administrative investigation for months? And why are you trying to open one that's already been handled 7 or 8 months ago by the prior administration? So is this commission going to say now that if the next commander doesn't like what a prior commander did, they can go and start a new investigation? It can be completely untimely, and y'all are powerless to stop it. Powerless to stop it. I don't believe that. And then the investigation rules don't say that we can request an investigation to any violation other than the rules in Chapter 12. It says of any rule, any rule. And it doesn't say we have to wait till it's over. It says any rules that are being violated or have been violated. That's what the law says. And interestingly, they don't deny the investigations are illegal. I mean, I invited them to do it. They know they're illegal. They know they're untimely. So again, we're not saying they can't conduct it. The law tells them how to conduct it. What we're saying is you have to follow the minimum standards. And they're not burdensome. They're minimum standards that this commission has enacted. So here we are. Here we are. We're here. Are y'all going to enforce your own mandates? That's the question. They have the right to conduct an administrative investigation. The only caveat is, state police, you have to follow the law. You're not above it. Just because you wear a badge, you're not above it. You know, the ends don't justify the means, so all eyes are upon this commission. Are you going to enforce the mandates that you've enacted, that y'all oversee? That's where we are.
Thank you.
Commissioner, can I have one quick response?
30 seconds.
With regard to why no administrative investigation was started when the criminal did, the Louisiana Supreme Court says we don't have to. Under the O'Hearn versus NOPD case, a criminal case tolls the administrative investigation, tolls the need to initiate.
That's not true. That's not, no, it suspends the 60-day period. You can't you can't mistake the law.
Will you please be quiet for a
If she
minute?
doesn't mistake the law, I
Or
can't.
you wanna step out for a minute
No,
instead?
sir, I'm fine.
Okay, well, let the lady finish what she's saying, not interrupt again. Nobody interrupted you. I'm not gonna sit here and let that happen.
I agree, but she needs to state the law correctly.
Well, if you need something to say, you wait till I finish speaking, as well as let her finish speaking.
Yes, sir.
Let's listen a little politeness here.
Yes, sir.
The O'Hearn case does stand for the fact that a criminal investigation tolls the time delays in the administrative investigation. The rule, I think opposing counsel correctly states, the rule talks about staying an administrative investigation. But O'Hearn, the Supreme Court says the criminal case tolls the investigation, which means nothing is happening. There's no need to do anything with the administrative investigation. I also want to say we were asked not to talk about the merits, but they've gone into the merits. They only pleaded that a sergeant knew. So they haven't even pleaded up
Yeah, that's
an
a lot more than 30
allegation.
seconds.
I was interrupted, but okay.
Well, that's, even with the interruption, it's a lot more than 30 seconds. All right, thank you. Okay. We can proceed. Do we have any, I take it y'all argue both of those together. I take it unless I hear otherwise, there's no objection to us considering both of these at the same time.
2 and 3, sir?
2 and-
Yeah, no objection.
No, sir.
So relative to the matters, relative to number 2, I would make a motion that we decline the investigation. And the basis of that motion is not that we do not have the power to do so. However, the basis of it is that there will be an opportunity at a later date to address each and every one of the allegations that have been made relative to the timeliness. And if there is an appeal of any discipline, we can investigate it at that time. So my motion would be that we decline the investigation at this time. We have a second.
I'll second.
Then moved and second. Any discussion? All in favor?
Aye.
Do we need to take a roll call vote? All in favor?
Aye.
Any opposed? The ayes have it. Decline the investigation at this time. Do you have any motions relative to number 3?
I would move with regard to the consideration of legal arguments to stop the pending administrative investigation that we.
Can I pause for 1 second before we go to the next one?
Okay. Well, I guess I'll just make a second motion. There were 2 issues in item number 2. One was to institute an investigation we've already voted on. I'd also move that we decline the second part of number 2 relative to the charges, to accept the charges that have been filed. Is there a second to that motion?
Second.
All in favor?
Aye.
Any opposed? The ayes have it. Thank you. Okay, I'm sorry, Commissioner.
With regard to consideration of the legal arguments as to whether we have the authority to stop the investigation, I think we can do. I would move that we defer that until we get a determination made as to the investigation, at which time the parties will have the opportunity again and full rights under our rules to bring it before us again.
Do we have a second to the motion?
Second.
Any discussion? All in favor?
Aye.
Any opposed? The ayes have it.
Thank you.
We We'll move on to item number 4, under the business item, public hearing to consider proposed changes to chapter 21 of the state police commission rules. Details contained